Hey everyone, welcome to another episode of our podcast, and we're honored today to have Lory Rosenberg again with us. So Lory, thank you so much for joining.
You're welcome. I'm glad to be here.
Beautiful. So we're really excited for this episode because this involves appealing your immigration court case should you not prevail at your trial hearing. And there's a lot that goes on with the appeal. People get really scared. What's going to happen? Do I have a chance? What is this whole Board of Immigration Appeals? And we're lucky to have Lory on our side. She used to be a board member. That means she used to be a judge with the Board of Immigration Appeals. She used to adjudicate these petitions. So she's the one that can really tell us the way to go. So we're going to talk a little bit about what the Board of Immigration Appeals is, what you can expect, should you not prevail at your hearing, some of the procedural steps you'll need to take, what happens at the board, and then as well as some of the standards that we're going to have to overcome in order to give you the best possible chance of winning, which is usually a remand back to the trial level. And we'll tell you all about what that means. So Lory, thanks again, and we look forward to sharing some great information with everyone.
Okay, great. Well, let me tell you about the board, a little bit about what it is and how it functions first. Before I forget, I want to make sure that everyone listening knows there is a document called the Board of Immigration Appeals Practice Manual, or Policy Manual, perhaps. And you can get it just look it up on Google. It's very important because even though the board is governed by regulations, federal regulations, this manual was written by the board, and it has all kinds of information procedurally and tactically for the way they want you to present your appeal. And so it's really an important document to take a look at and be familiar with, whether you're an attorney or a respondent doing their own case. So, okay, the Board of Immigration Appeals is governed by regulations, federal regulations that are enacted by the Attorney General. And the way it works is that when you finish your case at the immigration judge level and the judge renders an opinion either granting you the relief that you're looking for or denying the relief that you're looking for and ordering you to be removed, you can go to the Board of Immigration Appeals as of right, meaning that you don't have to show anything special. Everyone can take an appeal, but there are certain guidelines. So first off, you have 30 days to file this appeal. And it's really critical that you file your notice of appeal. That's a document, it's a form that you can get, and you fill it out. And it basically asks for, personal and biographical information. But the important part of it is the question that says, state your reasons for this appeal. And you want to be very clear in stating what was wrong with the immigration judge's decision. If the immigration judge precedent or law that the board has already stated, it's critical that you raise that. Or if the judge ignored facts that you presented in testimony or affidavits or documents, that's very important. So you want to point out the errors made by the judge, either as a matter of fact or as a matter of law. And you also want to talk about if the IJ, the immigration judge, abused his or her discretion. Much of the forms of relief that you can ask for at the immigration judge level, those forms are types of discretionary relief. And it's important that you point out where the judge went wrong if he exercised adverse or negative discretion and denied you relief. So you want to put all of that into this one box they provide, asking you the reasons for your appeal. If you don't put in there and provide something that refers directly to the immigration judge's decision or the record that you made in your case in front of the immigration judge, if it's not there, the board can summarily dismiss your appeal without giving you any further opportunity to brief it. And lots of times lately, the government attorneys, if the judge grants you relief, the government attorneys will ask the board to summarily dismiss your appeal, stating that
Wow.
you didn't provide or point out any errors, or that the judge was entirely wrong in granting relief. And they will ask the board to consider that. And oftentimes the board will reverse the judge's grant to you and send the case back. You don't want that to happen.
Wow.
Yeah.
So Lory, this can happen if I don't fill out the information correctly in the box that asks me the reasons for the appeal. And obviously, reasons for the appeal, they're not asking for a legal brief or memorandum at that point, but they are
Right.
asking at least for some reasonable, cognizable reason as to why
Right.
the IGA or immigration court made a mistake.
That's right. Now remember, when in the 30-day period that you have to take this appeal and fill out this notice of appeal, you won't have a transcription of the hearing. So there may be parts of the hearing that you don't remember exactly what the judge said, or if the judge cut off your testimony or refused to let an expert witness testify, you won't know exactly what the judge gave as a reason for doing that. So you have to, remember as best you can from notes that were taken what happened. And you can also put in your reasons that further reasons and arguments will be provided at a later time once you have received the transcript of the hearing. And that's just to let them know that they shouldn't look just at these points you're making in this very brief, fairly small box on the appeal form, the notice of appeal form.
You know, a
Now,
challenge we run into as attorneys, or if you're a client going to hire an attorney, let's say you did your trial case pro se, and you're going to hire an attorney, or you had an attorney in the trial level and you want another attorney to appeal for you. This new attorney, they don't have access to what happened in court. And they don't have access to the CDs. That's going to take a long time for them to be able to get the audio transcripts if they want to be able to listen to it. So essentially, in that box, we have to ask the client as many questions as we can and just kind of figure out what possibly could have gone wrong. And so we, able to fill that box out the best we can so we don't get a summary dismissal. Thank goodness it's worked every time, but, it does put us on the edge a little bit.
right. And it also, there are some cases where the judge actually issues a decision on the record and it's provided. So you may have a copy of the judge's decision,
Those
but
are
not
helpful.
always, right? You might have it, but not always. What I suggest, because the box is very small, is that you write in the box, please see attached page. And then you take a separate page and you write out your reasons why the judge was wrong or why the judge erred and didn't recognize your due process rights, why the judge ignored a Board of Immigration Appeals precedent that should have been controlling, why the board might have abused, why the judge might have abused its discretion, his or her discretion, and why the board should reverse and remand the case. Now, let's talk about, for just a quick minute, let's talk about some of the standards of review at the board. Okay, so there are certain types of rulings made by the immigration judge, such as a credibility determination and other factual determinations. Those rulings, including credibility decisions, are only reviewable by the board for clear error. And what that means is if the board thinks, gee, I wouldn't have looked at it that way, I might have looked at it another way, they're not going to find the judge's ruling wrong. The only way they're going to find it wrong is if they have a definite feeling that the ruling that was made is not supported by the evidence in the record or is way off of what would be acceptable as one of the reasonable decisions and rulings that the judge could make. So clear error is a very tough standard to meet. Now, the other things that the judge may have decided, such as questions of law, like what law controls your case, or even discretionary decisions that the judge made, Those are all reviewable under a standard called de novo. And de novo means like as though it was new from the beginning. And what that means is without having to look at or rely on the judge's ruling, the board can look at the all of the evidence. Once we have it, we'll be able to look at it too. It can look at the whole record, and on that record, it can decide as though it was deciding in the first instance. Okay,
Mhm.
so that gives the board a lot of much more power and ability to reconstrue some of the issues in your case. That can be a good thing, or it can be a not so good thing. And I have seen the board, for example, say we have de novo authority to make a discretionary call in this case. And if they think that the respondent's conduct was so egregious or so bad or undesirable that even though the judge granted relief as a matter of discretion, the board can say, we have de novo authority here, and we don't believe that discretion is warranted.
Wow.
Now, okay, now the only saving grace there is that the board is not allowed to make new factual findings. So if the board is going to disagree with the immigration judge, generally the case has to be remanded back to the immigration judge for further findings. For example, if you have somebody that has several uh, DUI or DWI convictions, driving under the influence, um, the board has a decision where it says, in a case of cancellation of removal, 2 of these DUIs are enough to call the favorable exercise of discretion into question. So
Mm.
if you have a client, and even though that client had 4 driving under the influence tickets or convictions, and the judge took that into account, but said, even given that this is a strong case and I'm going to grant it, but the board disagrees, the board can say, no, we don't think this is the right case for an exception, and
So,
we'll
Lory,
remand this back to the
in
judge.
that case, you're telling me that the government might appeal my victory in immigration court?
That's right.
Oh,
Yes.
man.
Yeah. And the government can also appeal not just on the discretionary issue, but also on, like in an asylum case. For example, one of the things you have to prove in an asylum case is the point called nexus, or what was the motivation of the persecutor? What was the relationship between that motivation and the ground of persecution? Say it was a religious persecution. Did the persecutor do what he or she did because of the respondent's religion? And sometimes I have seen the government attorneys saying, like, well, there is no nexus shown here. It could have been for many other reasons, like extortion or just general criminal activity. So it is possible for the government to appeal a grant of discretionary relief. And the case will generally get sent back to the judge. I want to make one more point now, since we're mentioning this, about um, the government taking an appeal. If you've won your case, but the government takes an appeal, they're the ones that have to write the brief and make the arguments. But that should not stop you from also filing a brief opposing the government's position. And so therefore, you want to make sure that you monitor that case. If you have an objection, if you think, for example, the government attorney has misrepresented what happened in the hearing, you want to challenge that. You also want to show if there is board precedent, a decision, for example, that might support the immigration judge's conclusions. You want to point that out. So you cannot just let them be the only ones to take a position in that appeal, even if you've won at the immigration judge level.
Beautiful, beautiful. You know, it can be a scary experience for people to be in that situation, but I think it makes a world of a difference, for them to have somebody experienced on their side. There's just so much that goes into this, and somebody taking the first crack at it, it's not worth being a guinea pig. I think you really need somebody with experience to know what's coming, and just that hand holding along this process, I think, is really important for people.
Yeah, and I'm happy to do that for people also. I mean, I do that a lot in the work that I do. And, it's not that difficult a process. I don't think people should be afraid of taking an appeal, but it has to be done right. And there are rules that govern it. And so you want to make sure that you give yourself every advantage, if you're the respondent, to make sure that the board really hears what you have to say. Now, I want to just say a couple things, perhaps, and we may have to close fairly soon, but I want to say a couple things about the board itself and how it's configured. At the board, there are anywhere between 15 to 21 board members or appellate immigration judges at any given time. And working for them are a team of attorneys called attorney advisors. Those attorney advisors are the ones that write the draft decisions of the board. And so they're the ones that are going to be considering your arguments the most closely. The board members or appellate immigration judges are likely to follow the attorney advisor's recommendation, because they work with them, they trust that they know what they're doing. And also, there's just too many appeals for them to individually sit down and pull up all the research necessary to decide any one case. So you have to be sure that you're writing and presenting your brief. You'll get a time period to do that once the government, the EOIR, when I say government, I mean the Executive Office for Immigration Review at the BIA, prepares a transcript of the proceeding. Once that's done, they will send you the transcript and a briefing schedule. You're allowed to ask for one extension of 21 days from that briefing schedule. You must do it within the time of the briefing schedule. You can't wait until you're late filing a brief and then ask for it. You have to file it in enough time so that they can respond and grant the extra time. If they don't respond in time, you're expected to file that brief, or otherwise have some incredibly, egregious situation that a lot prevents you from filing that brief on time. So it's really important to be aware of that and time it properly. And it has to be received by the board. This is true not just for the brief, but for the notice of appeal that comes before that. Those documents have to get to the board on or before the deadline date. They can't get there a couple days late. You can't say FedEx failed to deliver it or U.S. Postal Service didn't get it there on time. You're the one responsible. There are in Northern Virginia, where the board is situated, there are a couple of organizations that will hand file in person your brief. You just have to arrange with them and pay their fee, and then you will fax your brief to them or email your brief to them, and they will prepare it and take it in person over to the BIA and
That's
file it.
100 times better. Yes.
Yes,
Yeah.
it absolutely is. You're assured when you do that. It's even better than counting on an overnight delivery service, because you're assured that while that organization, one of them is IRAC, IRAC, the Immigrant and Refugee Appeals Center, they'll do it. And there's another one that I think is called something Visa, but I can't remember the name of
I've
it.
used some. I forget their names now, but yes,
Right.
lifesavers. Yeah.
And so the thing about having them file it for you is while they're there, they will get the docket clerk, the office where it's being filed, to stamp another copy, like the front page of your brief, so that you have proof that they will send back to you of when that brief was filed. You can show that it was filed in a timely manner. So that's really important to consider. I recommend doing that even if you have enough time, because I just want to be sure that it's there and that you get that stamp showing that it was filed in a timely manner. I think, the other thing, just to distinguish, if you're someone who has never engaged with the board on an appeal and you've been before immigration judges, that immigration judge hearing takes the form of a trial. It looks somewhat like trials that we've all seen in television shows or actual trials that are shown on TV that a lot of people have seen. Um, the the Board of Immigration Appeals handling of your appeal is not like that at all. The individual person, respondent, does not have to go to the board. And there's only one circumstance where they would go to the board, which I'll tell you in a moment. But the board does everything on paper. So they don't see you, they don't talk to you, they don't get to be impressed by your family showing up at the hearing or anything like that. They decide on the law and on the papers. And so that's why it's really important to be very specific, very detailed, cite the law, cite the facts. If there's an error that the judge made and you see it in the transcript, like maybe the judge didn't let your expert speak or cut you off when you were testifying, you want to quote that from the transcript. You copy the little paragraphs that you might see there where the judge said, "That's enough, Mr. So-and-so. Let's move on." And you copy that and put it in your brief with the page numbers so that the board can see exactly where that alleged error occurred. And the reason that you're doing that and the reason that you're referring the board to the law that applies is really because the attorney advisors who are reviewing these appeal briefs and writing the draft decision are basically, as I said, they're backlogged and under an incredible weight of appeals to be decided. The more that you can provide them, that they can quickly check and say, "Oh yeah, there, I see that on page 200 of the transcript. Good point." And then they may be able to include it as part of their decision. But it's critical that you are accurate about everything that you do and that you write in a way and provide the attorney advisors and the appellate immigration judges with a comfortable way to support your side of the case and grant your appeal or oppose the government's appeal if the government has taken an appeal. You don't want to do anything. You don't want to do anything, even if you're angry and frustrated and annoyed by what the IJ did. Maybe the IJ didn't let your expert testify. The IJ cut off the client, you or if you're an attorney, the client during the hearing, or said something insulting to the attorney. You don't want to say that unless you're making a legal point. You don't want to let them know also that you're a good person and that your whole family is here. That's not relevant unless it was something that came up in the case, and so you can't really deviate from the record very much. The more you put the situation in a context that can be easily believed and accepted by the attorney advisors and the appellate immigration judges, the more likely you are to win your appeal. And then what's going to happen usually is the board will remand the case back to the immigration judge. And that's a whole other situation that you have to prepare for. I mean, sometimes I've seen judges get very insulted when their decision was rejected at the BIA because they feel like, I got this right. I was the one sitting here listening to the testimony. And they really, they feel insulted. They look askance at what's being said to them in the board's opinion. And so they will give you a hard time on remand. Other times they just feel like they're busy too. If the BIA didn't like what they did, okay, fine. They'll grant the case this time.
It's
So
a
a
great
lot of times, right? What did
It's
you
a great
say?
feeling when it happens. Yeah.
Yeah, it's a great feeling. But I mean, you can't be sure of what kind of an outcome you're going to get on remand. So once again, I advise everybody, if your case is remanded, before you go out and celebrate, I would make sure you would want to prepare a brief on remand, arguing that the board's decision was correct in when they criticized the judge for XYZ.
Hey, folks, so Lory had to take another phone call. It was an urgent matter, and so she had to go. She's very busy helping us with these appeals and helping us change lives. And so, folks, let me tell you, a lot of times people say, oh, immigration is just about filling out forms. My friend got his citizenship. He filled out the forms by himself. Well, that's not very complicated, whereas filing an appeal with the Board of Immigration Appeals and citing precedents and knowing what the arguments are, it is something highly technical. In fact, something that we didn't have time to discuss today, if you don't raise a certain argument at the Board of Immigration Appeals, you want to give yourself a shot at the other appeal, which is the Federal Circuit Court, right? But if you don't raise it at the Board of Immigration Appeals because you didn't know you could even raise that argument, you look at the facts, you look at the law, and you didn't even know you could raise it. Your attorney didn't even think to raise the argument, and it could have been a good argument. You get to the Federal Circuit Court, you decide to hire a good attorney to do that. The attorney looks at everything, and he says, I'll do my best, but there is a great argument I would have raised if I had been handling the case of the Board of Immigration Appeals, but you didn't hire me then, so I can't raise it. I can raise it, but they're going to shut me down. They're going to say you didn't raise the argument at the Board of Immigration Appeals. So anyway, thanks for tuning in. If you have any questions, get in touch ASAP, because if you got a denial, you need to file, like Lory says, a notice of appeal within 30 days to protect your interests and to make sure you're secured your right to continue the appeals. You'll get the transcript many months down the road. Your attorney will, and then rock and roll. Look at that thing and see the errors that you and your attorney can identify and write the best appeal possible. Should I appeal my case? Well, if you want to stay in the United States, you kind of have no choice. So hire the best. It makes an enormous difference. All right. Take care. Be good to yourselves, and I'll see you soon.